while one consistent with the recommendation of the prosecution of less than 11 years would not. He then compares his case with the case of Milan Babić. As to whether the trial chamber erred by failing to explain why the sentence recommended by the parties was not appropriate, the appeals chamber recalls that trial chambers shall not be bound by any agreement by the parties, but that, nevertheless, in the specific context of a sentencing judgment following a plea agreement, trial chambers shall give due consideration to the recommendation of the parties, and, should the sentence diverge substantially from that recommendation, give reasons to for the departure. In the present case, the trial chamber found that, I quote, the recommendation made by the prosecution of a sentence of imprisonment of no more than 11 years would not do justice in view of the applicable sentencing principles and the gravity of Babić's crime, taking account of the aggravating and mitigating circumstances. End of quote. This shows that the trial chamber gave due consideration to the recommendation made by the prosecution and did explain why it could not follow it. With regard to whether the trial chamber erred in not imposing a sentence similar to that of Milan Babić, the appeals chamber recalls that the precedential effect of previous sentences rendered before the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda is not only very limited, but also not necessarily a proper avenue to challenge a trial chamber's finding in exercising its discretion to impose a sentence. Comparisons with other cases as an attempt to persuade the appeals chamber to either increase or reduce the sentence are of limited assistance, because the differences are often more significant than the similarities, and the mitigating and aggravating factors dictate different results. In this case, even assuming that the two cases were so similar as to be meaningfully comparable, the appellant's sentence is not so out of reasonable proportion with Babić's sentence so as to suggest capriciousness or excessiveness. The appeals chamber will therefore not engage in a comparison between these two cases. The appellant's second ground of appeal is dismissed. Under the third ground of appeal, the appellant contends that the trial chamber erred in law and in fact and abused its discretion in failing to properly consider and give appropriate weight to the evidence with respect to his alleged limited participation in the crime of persecution to which he pled guilty, and that his sentence should be accordingly reduced. The appeals chamber finds that the trial chamber was entitled to consider that the appellant's role in providing support to the joint criminal enterprise was not as limited as the parties suggested, and therefore the appellant's third ground of appeal is dismissed. The appeals chamber now turns to the appellant's fourth, fifth, sixth, and 10th grounds of appeal, concerned with the trial chamber's assessment of the mitigating circumstances. Under the fourth ground of appeal, the appellant argues that while the trial chamber acknowledged, but by agreeing to substantially cooperate with the prosecution, he incurred substantial security risks for himself and his loved ones, it erred in law and in fact and abused its discretion by considering this only as a mitigating circumstance, instead of as a substantial mitigating circumstance. The appeals chamber finds that this argument is without merit, as the trial chamber in fact expressly stated that it gave substantial mitigating weight to this factor. As a result, the appellant's fourth ground of appeal is dismissed. Under the fifth ground of appeal, the appellant contends that the trial chamber erred in law and in fact and abused its discretion in finding that, in the absence of exceptional circumstances, the prior good character of a person does not as such count in mitigation. The appeals chamber notes that, while it is correct to say that good character has been recognized as a mitigating circumstance in most cases, this is not constant practice, but instead varies with the circumstances of each case. Even when personal factors or circumstances, including prior good character, have been considered as mitigating circumstances, they have been given little weight in mitigation. The appellant in the present case has not demonstrated an abuse of discretion, and the appeals chamber finds that the trial chamber was perfectly entitled not to attach any weight to the appellant's prior good character as a factor in mitigation. The appellant's fifth ground of appeal is therefore dismissed. Under the sixth ground of appeal, the appellant argues that the trial chamber erred in law and fact and abused its discretion when it failed to accept his conduct subsequent to the crime as a mitigating circumstance. He submits that the sentencing judgment's discussion of his conduct subsequent to the commission of the crime for which he was convicted fails to mention that he tried to facilitate an attempt to bring an end to hostilities in conjunction with Peter Galbraith, United States Ambassador to Croatia, along the lines of the Z4 peace plan, and that he tried to alleviate problems in the prisons by employing professional staff. The appeals chamber considers that the trial chamber incorrectly interpreted the Plavšić trial chamber's assessment of Biljana Plavšić's post-conflict conduct, in that it erred in finding that the appellant's conduct subsequent to the crime of persecution could not be considered in mitigation solely because it did not include the alleviation of the suffering of victims. Further, evidence of the appellant's conduct subsequent to the commission of the crime, relevant to his contribution to the advancement of peace, was available to the trial chamber. The appeals chamber is satisfied that the appellant attempted to further peace after the commission of the crime of persecution, and finds that the trial chamber erred in law in categorically refusing to take these attempts to further peace into account as a mitigating factor on the basis that they did not directly alleviate the suffering of victims. Nevertheless, in the opinion of the appeals chamber, such an error does not automatically lead to a reduction of sentence, and in light of the gravity of the crime for which the appellant was convicted and the circumstances of their case, the appeals chamber finds by majority that significant weight did not be given to the appellant's attempts to further peace. With regard to the appellant's argument that the trial chamber should have taken into account that during the period covered by the indictment, he attempted to alleviate problems within the prisons by appointing professional prison staff, the appeals chamber notes that, as acknowledged by the appellant at the appeal hearing, this argument was raised for the first time on appeal. The trial chamber did not therefore commit an error in not considering this factor in its assessment of the mitigating factors. There is no evidence on the basis of which the appeals chamber can consider this submission. In addition, the appeals chamber recalls that an appellant cannot expect the appeals chamber to consider on appeal evidence of mitigating circumstances which was available but not introduced in the first instance. Under the 10th ground of appeal, the appellant alleges that the trial chamber erred in law and in fact and abused its discretion by failing to afford the appropriate weight to the totality of those mitigating circumstances which it found did exist, namely his admission of guilt, his substantial cooperation, his expression of remorse, his voluntary surrender, and his personal and family circumstances. The appeals chamber did not address the issue raised by the appellant as to whether, taken in amalgamation, the mitigating factors referred to by the appellant were properly weighed by the trial chamber, as an appellant can only succeed in challenging a trial chamber's decision regarding the weight afforded to a mitigating circumstance by demonstrating that the trial chamber committed a discernible error concerning a specific factor. Rather, the appeals chamber addressed the alleged errors with regard to each of these mitigating circumstances in turn and found that the appellant did not show that the trial chamber committed a discernible error in the exercise of its discretion in considering the mitigating circumstances in question. Under the 7th ground of appeal, the appellant submits that the trial chamber erred in law and in fact and abused its discretion in finding that he held a leadership position in the joint criminal enterprise and in considering that as an aggravating factor, thereby imposing a more severe sentence.